Hello, my name is Mrs. Smith. I understand that you've taken over your family business. You want to commercialize food products and have questions about intellectual property. Intellectual property refers broadly to the creations of the human mind. The property rights protects the interests of creators by giving them property rights over their creations. Intellectual property is usually divided into two branches: industrial property and copyright. Industrial property relates to all manufactured or natural products and methods and services. Copyright relates to artistic creations such as poems, novels, music, paintings, and cinematographic works. To get from the idea to industrial property rights, IPR. The generation of IPR is based on an understanding of protecting ideas created within a company. It starts with the idea creation with a clear intention that created ideas generates value to the company and business. The value can be direct, such as a business model or a patent, adding revenue, or indirect, such as know-how or trademarks that strengthen the company but is difficult to measure in terms of revenue. So how do you proceed? Do you make it public? Do you keep it as your own? If you make it public, it means that anyone can make, use, sell, or import the product or method that you have innovated. The drawback is that you can lose money if other companies produce exact the same product, but the advantage is that no one can take a patent to this idea. So let me give you an example. If you have a product which is easy to produce and has a short lifetime, it may be favorable that you make the idea public because the patent procedure can take a long time and is often costly. Keep it your own. This means that you either keep the idea confidential as your own or you protect it legally. The legal protection consists of patents, utility models, registered trademarks, and/or registered industrial designs. In this way, you collect an IPR portfolio. An IPR portfolio is a collection of rights you and your company can use comprising of your own IPR and that what you have acquired, i.e. licensing. Let me present IPR systems. An IPR is a complex area of law that holds many dangers for inexperienced companies. Therefore, it is favorable for a small company to use a patent attorney who can help you when you're planning an effective IP protection strategy, and of course if you decide to patent your idea. Your patent attorney should be able to advise you fully on IP matters in your own country and of all Europe. You need to have a general knowledge of the area so you acquire the right competence to select the strategy with an advisor. Protecting your idea. Keep your invention confidential before protecting it legally. Protect your innovation against infringement when you begin to use them. In order not to make an infringement to others' rights, detect existing rights such as patent, trademark, etc. by using a freedom to operate search. If there are existing rights, try to adjust your product or method in the way it does not make any infringement. This is simpler and less expensive to perform before your products have entered the market. You can also try to invalidate existing patents or subscribe a license. If other parts makes an infringement against your patent, contact a patent attorney if you do not have the knowledge to process it yourself. How to do. Type of product or service. Here, you analyze and try to predict the future for your products or services. Investigate what kind of products or services your idea would generate. Risk involved with the product such as investment, time for revenue on invested capital, competition, and national and international sales. The type of protection. Usually for a final product, there's always a need for registering the trademark. This is a simple and cheap protection that ensures you from competitors using your trademark. You can apply for a patent or utility model and/or register the design for technical ideas. You can also register design for ideas which do not solve technical problems such as website. Financial consequences. Calculate costs linked to IPR and determine if it's worth it for you. This is a risk assessment because for any company there's a balance between costs and risk. IPR protects you but will cost, and you have to determine if and when you need IPR based on your revenue and competition. Your market potential. Who are my customers? Depending on if you're selling directly to customers, for example a B2C, then it's vital to protect all trademarks, while know-how and agreements are more important when you sell to other companies, B2B. Who are your competitors and how large is their market share? This is of importance since it has a huge impact on the needs of rights. If your competitors are large corporations with big market shares, then you need IPR to protect your market share. What is the lifetime of the product? Is the lifetime of a product long? Then it can be worth applying for patents, since the initial costs for patents are high, while if the product lifetime is short, then design and trademark are preferred. IPR for small companies. In general, the problem is to expand your business without losing too much money, and the initial part of the expansion, with other words, risk handling. We'll provide you some thoughts on a way for handling IPR for small companies. The essential part of IPR is trademark, because if you have any intention of expanding your business, then you should protect your company name and the names of your products. The cost for this protection is quite low. The dividing point for the other rights is fundamentally based on amount of initial investment for research and prototyping, as well as future investments need. If you need large investments, then you need stronger IPR, such as a combination of trademark, design, and/or patent. The important part for you is that you have an IPR strategy when planning expansion, what IPR to use and when. Since you do not need to use all or nothing, you could start with trademark and after expansion use other rights appropriate for your products and your economic strength. One important aspect that you should take into consideration is if you can protect your rights. This means that you need resources to monitor if anyone is infringing your right and act when infringed. The action should lead to court, which costs and sometimes is a strategy from some competitors since they are aware of economic strength of their competitors. A patent. A patent is a right granted to an inventor which allows the inventor to exclude anyone else from commercially exploiting the invention for a limited period, usually 20 years. The patent is also limited to the country, the authority of which has granted the patent. By granting an exclusive right to the patent owner or patent holder, the patent system aims to encourage to publish the inventions so that others can gain the new knowledge and can further develop the technology. The patent owner has the right to prevent third parties without the owner's consent from making, using, offering for sale, selling, or importing for these purposes the product or preventing from using the process or method for making the product. Utility model. Utility models are used to protect inventions, especially in the mechanical and IT field. They are sought for technically less complex inventions or for inventions that have a short commercial life. This right is not available in all countries. Examples of countries with this right are China, Germany, and Finland. The protection is usually granted for 7 to 10 years. Trademark. A trademark is a sign or a combination of signs which distinguishes the goods or services of one enterprise from those of another. The owner of a registered trademark has an exclusive right in respect of his mark. It provides the owner with the right to use the mark and to prevent unauthorized third parties from using the mark, or confusingly similar mark, so as to prevent consumers and the public in general from being misled. The period of protection varies, but a trademark can be renewed indefinitely on payment of corresponding fees. The industrial design. Industrial design registration protects against unauthorized exploitation of the design in industrial articles. It grants the owner of the design the exclusive right to make, import, sell, hire, or offer for sale articles to which the design is applied or in which the design is embodied.